You know somebody's about to make a courtroom situation 10 times worse when they walk in acting like the law only applies if they personally agree with it. So today, we've got a full-blown conspiracy Karen who honestly believes the court can't prosecute her unless she gives permission first. Yeah, this one gets ridiculous fast. And somehow, she manages to turn a normal hearing into a complete circus almost immediately.
2300820M. This is Van Buren Township versus Lindsay Dineski.
Yes,
Nancy
ma'am, that's me.
on behalf of the people.
I'm sorry, ma'am. State your name for me again.
Lindsay Dineski.
Thank you. Today is the day and time set for the arraignment and pretrial in this matter. Ms. Dineski, the way the court staff have you labeled indicate that you're waiving your right to have the assistance of the court-appointed attorney. Is that correct, ma'am?
Yeah, I'm studying to be a lawyer. I would not need that.
Now, apparently, she claims she's studying to be a lawyer. But let's be honest here. Filling out a junior college application and watching conspiracy videos online does not make someone a legal expert. This is one of those self-appointed constitutional scholars who thinks a couple months of Googling suddenly means they understand the entire justice system better than actual attorneys and judges. And the confidence? Completely unmatched. The knowledge? Not so much.
That being the case, have you had the opportunity to speak to Ms. Manarino this morning?
Yes. I
Ms.
think all
Manarino,
charges should be dismissed because this is retaliatory action for asking for a child to be protected.
Ms. Manarino, how are we proceeding this morning?
Your Honor, based on my discussion with Ms. Dineski this morning, she is requesting to have the matter set for a jury trial.
I'm actually requesting for dismissal, and she insisted that I either take a plea or go to trial. But I think that it should be dismissed because it's retaliatory and it's in violation of several of my rights, Michigan and federal rights under the Constitution of both.
Then comes one of the funniest moments early on. She starts talking like she already understands how court works while completely mixing up an arraignment and an actual trial, which is kind of a huge problem for somebody pretending to study law. Because one hearing is basically where charges are addressed and pleas are entered, and the other is where evidence actually gets argued. That's basic first week stuff. So the second she confuses the two, you can already tell this courtroom adventure is heading straight for disaster.
Plea not guilty.
Thank you. That's the recommendation from Van Buren Township, ma'am, is that they do not oppose personal bond, and that was going to be the court's intent. Set your bond at $5,000 personal. You do not need to post any money. But what you must do is continue to appear as directed by the court until this case is resolved in its entirety. The arraignment having been completed, the next step is pretrial. You've both already indicated that you've had some conversation regarding pretrial. Ms. Dineski, I understand that you have a defense that you want to present. Today is not the day and time to present that defense. If you want the matter scheduled for a jury, the court is happy to schedule the matter for a jury trial. In an interim, there's also a request that you have no contact with Charles Nerswick, Nerswick. Do you have any reason to be in contact and communication with that person?
Yeah, we have children together, and he kidnapped one of our children, which
Your
is
Honor.
what I was actually calling the police about. And he has our child in danger, and they refuse to listen. And now she's gone. She's missing. So I will be countersuing Romulus, or I guess it would be Van Buren. And if the court proceeds with this, I will be also bringing the malicious prosecution against this court as well.
And of course, eventually she starts threatening to sue everybody. The court, the officers, probably anyone within a 20-foot radius who disagrees with her. But honestly, nobody in that courtroom even looks surprised anymore. You can tell they've dealt with this type before. The kind of person who throws lawsuits around like emotional tantrums anytime reality doesn't go their way. At this point, the threats don't even sound intimidating. They just sound exhausting.
Because these are erroneous charges and they're retaliatory, which is a violation of my freedom of speech. It's a violation of my right to due process. So if this does not get dropped today and it moves forward, I will be filing under color of law lawsuits against Van Buren and this court in federal court for violation of rights under federal question jurisdiction. So I just don't think it would be a good use of the court's time or resources to continue this malicious prosecution. And I could quote case law. I could quote laws that Van Buren police broke. They completely ignored my evidence. There was obstruction of justice. They said there was sexual discrimination against me because I was a woman. I have all the calls recorded. I mean, it would really be a waste of the court's time.
Then she has the nerve to complain about people wasting the court's time, which is honestly incredible considering she apparently has multiple ridiculous lawsuits already filed against her husband and different law enforcement agencies. And the accusations are absolutely wild. According to her version of events, officers supposedly ran her off the road, then magically switched personalities and started helping her the moment she began recording. Convenient timing, right? And naturally, she throws in all the classic sovereign citizen phrases too, claiming violations of rights, unlawful prosecution, government conspiracies, the whole package. At this point, it feels less like a legal argument and more like someone reading conspiracy theories directly off Facebook.
The one who broke the
Miss-
law was Van Buren Township, not myself.
Ms. Dineski, I said it before, and I'm not sure if you heard me or understood that today is the arraignment. Today is the
Yes,
first
but
appearance where
I
you
could ask for
respond-
it to be dropped at the arraignment. I'm allowed to ask for the charges to be dropped because they're erroneous. So my liberty should not be affected by erroneous charges. I should not have to keep showing up at court and have a bond. That's a violation of my liberty. This is malicious prosecution. Chuck has friends at the Van Buren Township. His father used to be the fire, one of the high, like he was like the assistant fire chief. So there's bias there. They refused to listen to me. He tried to kill me, and then he took our child. And when I talked to the police about it and said that under Michigan law, he should not be with a child because he's suicidal, homicidal, and he's isolating with a child, everybody ignored me. And then they pressed charges against me for asking them to help me.
Honestly, the most shocking part of this hearing might be the rare moment where she actually stops talking long enough for someone else to speak. Because up to this point, it's just nonstop rambling, interruptions, and accusations. And then she expects everybody to believe that police randomly arrested her simply because she asked for help. Yeah, that story's gonna need a little more work.
Ms. Dineski, just so you're clear, this matter is being recorded and we're streaming live on YouTube. I only say that so that you may be mindful of the things that you say. Ms. Manarino, you were starting to say something.
Yes, Your Honor, as it relates to bond, I understand that Ms. Dineski has an issue with the no contact. When I spoke with the complaining witness in this matter, he did indicate that he did not have an issue with Ms. Dineski having contact with him as it relates to the two children, the two biological children they have in common. As it relates to any other matter, he would not like to have contact from her during the pendency of this matter.
So, Ms. Dineski, I will ask you the question a different way. Do you have any reason to be in contact with Mr. Nurswick other than to make arrangements regarding the children?
Haley is my child. She's not my biological child, but legally she is my child. I've cared for her for 5 years. I'm the only mother she knows. So yes, I should be able to have contact with him regarding Haley because he kidnapped her legally under Michigan law. I am a parent and I have as much right to her as he does as a biological parent.
Then the conversation shifts toward the child custody situation, and things get even messier. Because the court starts pointing out something she clearly doesn't want to hear. If she never legally adopted the child, then she doesn't automatically have parental rights. That's an entirely separate legal process. Now, sure, courts can sometimes allow visitation if it benefits the child, but looking at the way she behaves, that argument starts falling apart pretty quickly. Because instead of sounding calm or concerned, she sounds completely consumed by paranoia and conspiracies. And honestly, you can almost feel the court wondering whether any child should be dragged into this chaos at all.
The court, when gave him custody, used me as a deciding factor as to why he got custody of that child. So that actually, just that particular statement shows that this is about him abusing myself and Haley and using the court to as a shield to keep a mother away from a child. And the fact that he took her away from me, she's not been away from me more than 3 days since the day I met her, and he hasn't let me talk to her in 2 months. And that's extremely mentally damaging to her because she already has issues because when I met her, a bio mother had abused her and neglected her, and I had to work with her for 5 years to even get her to be able to be at the same level as somebody her age because she was so behind due to the abuse and neglect from Charles and the bio mother.
And the deeper this goes, the more obvious the pattern becomes. Nothing is ever her fault. According to her, everybody else is always the abuser, the liar, the manipulator, the problem. She paints herself as the hero in every single situation, the only sane person surrounded by corruption and evil people. But then the details start stacking up, and suddenly the story stops making sense. The contradictions become impossible to ignore. And when she claims the child has been mentally damaged simply because she hasn't seen Karen for 2 months, honestly, that might have been the most peaceful 2 months that kids had in a long time.
And now he tried to kill me. He said he was suicidal and then kidnapped our child and then used Van Buren police to maliciously prosecute me when I tried to assert my rights to that child and my right to protect that child. So again, the only people who have committed any crimes here is the Van Buren police and Charles Nerswick.
Ma'am, the court will impose a condition of bond that you have no contact with the complainant in this case, except as is necessary to make arrangements regarding the biological children. I heard your request for a jury trial, but I've also listened to the comments that you just made, and I want to disclose to you that I am married to an elected official in Van Buren Township. He is not involved in the day-to-day operations of the Public Safety Department, the issuing agency in this matter. But based on the comments that you've made, ma'am, I'm not sure if you wish to have this case remain here with me, or if this matter should be adjourned to Judge Green's docket. She next takes the Van Buren Township docket with a date available on April 20th for a pretrial conference. How do you wish to proceed?
Is that where I can ask for it to be dismissed?
You can make that request at every hearing, ma'am.
Well, that's what I was doing today, but you said that that was not appropriate.
Because there's been nothing received from the court other than the charges. So the arraignment is just the reading of the charges, the setting of bond, and then the scheduling of the next matter unless the parties have reached an agreement. So
well, that's what I'm asking for the agreement due to the fact I was not given any evidence. I wasn't.
Then she starts acting shocked about the idea of discovery in court, which is hilarious considering she supposedly studies law, because discovery is one of the most basic parts of the legal process. At this point, it really feels like she memorized random legal buzzwords without actually understanding what any of them mean.
And like I have proof that Chuck took this and tried to use it in a court to try to kidnap the biological children from me. And the court didn't grant it because it was, again, erroneous and the court saw through that. But he conspired with the Van Buren police to have these charges brought against me, and he perjured himself. The Van Buren police perjured themselves when they asked for this warrant. I was not given the information. I was not given the information as to what I did wrong. They kept that information from me. I was not properly served on this matter either. I mean, everything is completely improper in this entire case. Plus, it's erroneous and they're false charges.
Ma'am, are you requesting information from Ms. Manarino at this time?
I mean, I called and asked for information back when I first got the letter, and nobody would give me anything. I've called and I left her messages, I think, at least twice. So, yeah, I would like to have every single thing that they use to get an erroneous warrant on me.
Ma'am, based on that, the court will make an indication in the file that you've requested discovery. Now that you've requested discovery, we'll put the matter over to Judge Green's docket. That will be
April 20th at 9:20.
April 20th at 9:20 in courtroom number 3, back on Zoom with Judge Green. Ma'am,
and I would like to know why I would not be allowed to talk to Charles about my daughter, Haley. I will not abide by that, by the way. I will not. That's illegal. And I do not have to abide by an illegal order.
Eventually, the judge finally makes something crystal clear. She does not have to like the court order, but she absolutely has to follow it. Because if she keeps refusing, she's not just risking sanctions anymore. She's risking contempt of court. And suddenly, The fantasy world where she can ignore legal orders starts colliding with reality. Fast. The judge basically warns her that if she keeps this up, her future law studies might continue from a jail cell instead of a classroom.
April 20th with Judge Green, ma'am. The court will mail notice to the address that we have on file in this matter. Anything else, Ms. Manarino?
And no, Your Honor, thank you.
I do
Anything
not
else, Mr.
consent
Husky?
to this, by the way. I do not consent to this interaction. I do not consent to these charges. I do not consent to any of it. It is erroneous, and I will be taking legal action against this court for not dropping this today.
And honestly, that's probably the perfect way to end this whole mess. Because throughout the entire hearing, she acts like her personal feelings and sense of entitlement should matter more than actual laws, court orders, or procedures. But courts don't operate on emotions. They operate on rules. And no matter how loudly she argues, threatens lawsuits, or screams about conspiracies, none of it changes the reality of the situation. In the end, all she really accomplished was making herself look less credible every time she opened her mouth. And somehow, you get the feeling this courtroom chaos is far from over.